Welcome to Trautman Pepper's podcast, FCRA Focus. This podcast series is designed to educate, inform, and hopefully entertain you as well on all things related to the Fair Credit Reporting Act. To stay abreast of these issues and to make sure you don't miss an episode, please subscribe via iTunes, Stitcher, Google Play, or wherever you download your podcasts. And now, your host, Dave Gettings.
Welcome to the second edition of the FCRA Focus podcast, the podcast dedicated to issues related to the Fair Credit Reporting Act and associated credit reporting. Today we're joined by Kristi Kelly, one of the founders of Kelly Guzzo. Kristi is based in Northern Virginia, but she litigates FCRA cases throughout the country. And Kristi is one of the most recognized names from the plaintiffs' bar with respect to FCRA litigation, including FCRA class litigation. She's got multiple jury trials and significant class settlements to her name. And while reserving the right to challenge Kristi's adequacy in any class certification battle, I will say that Kristi is one of the most formidable FCRA class action lawyers that's doing plaintiffs' work in this space. And so I'll compliment her on this podcast, but not in court. Given her experience and work on the plaintiff side of these cases, we thought Kristi would be a perfect interview for the FCRA Focus podcast. So with that, Kristi, welcome. Thank you for being here.
And thank you, Dave, for having me. I really appreciate the opportunity.
Perfect, of course. Maybe this will be a little marketing for you if plaintiffs' counsel market, which I don't really know. So we'll see. Kristi, just if you would start, tell us a little bit about your practice. You know, the audience is people that listen to an FCRA podcast. So you've got to assume that they either really like credit reporting or are in this space already. So just give a sense of what your practice entails.
Sure. So I practice exclusively consumer law, and it includes a lot of Fair Credit Reporting Act litigation, but I also do some mortgage-related litigation, including how it ties into credit reporting work. A lot of the credit reporting cases we do are sometimes class actions as well, because we identify what we perceive to be problems in the marketplace that affects consumers. And so our objective is to fix those problems on a larger scale than for our individual clients. So we do all kinds of FCRA litigation, individual cases, problem solving, baby cases, to large class actions against various entities, different big three credit bureaus, background screening companies, tenant screening companies, some of the subprime consumer reporting agencies as well.
Sort of what I guessed based on my experience with you. So we're going to ask you a few questions about your practice, try to get a little insight into how you operate, but we don't want to get the secret sauce if it's something you don't want to give. So let's come up with a safe word about whether we've gone too far in a question. What do you want to say where it says, Dave, pause, we're not going to answer that question?
I'm pretty open, as you know, of the way I see it being a plaintiff's lawyer. We come into court and we show our cards, and there's not much that I'm not willing to disclose, absent, of course, confidential settlement amounts and things that I'm legally prohibited from disclosing. So.
Okay, I promise we will not ask you confidential settlement amounts. All right. So first question, how did you get into consumer financial services? Is it something you always wanted to do, or did you just sort of stumble your way into it?
So I don't consider myself a consumer financial services lawyer. I'm a consumer protection lawyer, right? And so I represent the little guy against big companies. And so I started at Legal Aid representing, tenants who were being evicted by landlords and trying to help them, secure their housing. And as I learned about other problems consumers had, I learned a lot more about consumer law and how important it is to advocate and educate consumers of their rights, because financial problems can really have a detrimental impact on consumers. And then part of that segued into credit reporting. If there are problems with a consumer's credit report, it could prevent them from obtaining housing, obtaining employment, obtaining credit to buy basic necessities. And so it is a very important aspect of many people's lives who may not have wealthy parents or grandparents and need credit or need jobs to survive. So
you mentioned in your answer, you mentioned both mortgage, you mentioned tenant screening at one point. Do you foresee that there's a particular industry in credit reporting, whether it's tenant screening, mortgage, that's going to be sort of hot for the next year? That's the more attractive industry that plaintiffs' counsel are going to focus on?
I do. I think the tenant screening background checks have been a much hotter topic with this administration. And because of the issues surrounding certain public policy issues about evictions, preventing tenants from getting housing, and the push from some reforms on, obtaining housing and the barriers to housing, and the more research and studies that have been done about the issues that tenants face when they're trying to obtain housing. I think a lot of tenant screening companies with the CFPB leadership that is in place will have a lot more scrutiny because of how a lot of them operate, particularly with eviction reporting and public record, including criminal record reporting. The big eviction reporting issue, I think, that is going to come up is that a lot of tenant screening companies just report whether there was ever an eviction action filed, and they don't always report the outcome of that action. And they always say, oh, well, our clients don't care, it doesn't matter, just the fact that an eviction action was filed, you got the scarlet E for eviction, you're no good. And I think that's a real problem. And I don't think that complies with the language in the Fair Credit Reporting Act, because it's incomplete information at best and misleading and inaccurate at worst. And so I think that's going to be something that has a lot more scrutiny coming, with the way that the climate is right now. And I think those cases are good cases, and I would definitely take them.
Yeah, we've litigated a couple with you on those. So
right.
you didn't choose a safe word, so I'm going to ask you this question. So you mentioned government regulators. What's your sense of how closely the plaintiffs' bar actually works with government regulators, or gives insight or coordinates with? If that's a fair question, let me know.
Well, I think as someone in the plaintiffs' bar, you want to improve the marketplace. And being realistic, there are some things that you can't change because you are a plaintiff's lawyer and you're not a government regulator. You have to deal with arbitration, certain statutes or laws that may not be enforceable from a private plaintiff perspective. But government regulators have a lot more sway and power and tools in their arsenal. Whenever I'm asked for my opinion or, information, I am happy to help improve the marketplace and provide information to the extent it would not violate any confidentiality orders or be to the detriment of any of my clients, or contrary to, like I said, a court order or something like that. I've never provided documents or anything like that. I usually get asked my opinion on something, or hot topics that they think, or things that I've seen that I am unable to do something about because of, arbitration or other things like that.
So I take that to mean there's some coordination. And I also say, if the CFPB reaches out to me, I'm happy to give them insight into how to improve the marketplace, although it probably will be different than your suggestions as to how to improve the marketplace.
Yeah, it's total one way. There's no coordination. It's a one-way street, right? I get nothing in return if I ever give anything. And like I said, it's just observations or opinions. It's nothing proprietary. It's just my sense of things from seeing consumer reports or talking to consumers, and sometimes my angst at being unable to help somebody or resolve something because of, like I said, arbitration provisions or how something is drafted, et cetera.
Right. So as a defense counsel, we always sit back and say, man, plaintiffs' counsel have it really easy sometimes because we always have to update clients and write long reports. And if we could just spend all that time thinking about our case and strategizing about our case, it would make a difference. So that's probably jaded, but what is your most frustrating part about being a plaintiff's counsel in this space, and why is it frustrating for you?
I wouldn't say I'm ever frustrated being a plaintiff's counsel, right? We get to pick our clients. I consider myself very lucky to be able to do what I do. With that being said, the perfect case just doesn't stumble in your door wrapped up in a bow as a perfect case. And so you have to go through a lot of kiss a lot of frogs to find the prince, right? And so you deal with, a lot of consumers who have problems and who have needs where there may not be a remedy that is obvious or something that you can do to help them in a way that will make the difference that they need. And so, my office does a lot of pro bono work because, we're pretty sympathetic in my legal aid background. I understand that if we don't step up and do something, nobody will. And the problems that consumers can face if you don't address their issues. But that being said, when you do find, good FCRA cases, and it is very competitive to get a good FCRA case, it's really important to understand your client's expectations and make sure that you feel like you can meet them, because sometimes there are people who have expectations that just are not in line with what I perceive to be the value of their case. And so that can be really difficult. The other thing that can be difficult is that a lot of problems with credit reporting are immediate, and sometimes the damage has already been done and there's not something you can do to really undo that damage. And so you have to really work with your client to help them understand what you can do with the FCRA and help them understand the process, because it does take time. The other thing that I will say too, it's really difficult, is that people want to stop the information from ever, occurring on the report again. And they won't stop until they find patient zero who gave the information, and it, in the age of the internet, it's very difficult to find where the information actually came from. It may not have been the source on a disclosure, or even if it was, can you stop it from being out there again? And, there's really just no guarantee. And so a lot of times you can't always meet the goals of your clients, and just helping them understand that and work through that process, is something that all plaintiffs lawyers need to do.
So you said it was competitive to get a good FCRA case. Do you find that plaintiffs shop to different plaintiffs firms, or what do you mean by competitive?
I mean, you mentioned it earlier about advertising. There are a lot of firms that advertise, like SEO, Google Ads, all of that stuff for FCRA cases. My firm, we're not very good at that. And most of our stuff, our cases that we bring, they don't actually come, with that particular problem. They come with some other problem. And when you assess their situation, you realize it's really an FCRA type problem. But there are a lot of law firms that, heavily advertise and spend a lot of resources marketing for Fair Credit Reporting Act cases. And it is becoming a bigger and bigger thing for plaintiffs' lawyers, that it is just very competitive to market and get a good mixed file or whatever type of FCRA case that you think that, is, meritorious.
Yeah. Have you noticed any increase in FCRA filing, or I guess I should say FCRA plaintiffs firms, with the TCPA being sort of gutted by the Supreme Court? Have you noticed people moving over from TCPA to FCRA?
Yeah, there are a lot more people that are trying to get into the Fair Credit Reporting Act than there used to be. And I don't know where they come from or what their backgrounds are, but, we go to conferences and speak at different, sessions, and, even just being asked to be local counsel on different cases. There's just people that, in what used to be a much smaller community, there's a lot more people in the community or trying to become a part of the community. And, that it's a challenge. You always want to share information and be a good community member, but it could be problematic because there are people who are making bad case law. And I'm sure you guys are super happy about that.
We are.
but or maybe it's just you guys that are making the great case law and to their detriment. But yeah, you always want to make sure that you're always thinking, first of your client and also of the greater good. So
yeah, makes sense. I always know what the plaintiff's pressure points are. You always try to serve discovery early. You try to get us in a deposition, try to look for a bunch of documents. And we always sort of wonder, what are the plaintiff pressure points in terms of what do you guys not like doing? So what do you not like doing? What do you is it if a defendant is just briefing a bunch of motions that take time? What is a pressure point for plaintiff's counsel?
A couple things. So not necessarily a pressure point, but I never understand why sometimes things have to be so adversarial, right? A lot of times, you deal with a new lawyer representing an entity maybe you've never sued or, haven't sued much, and they just want to go out and have like a knife fight, right? And you're, and all you want to do is, I want to make my client happy. I want to solve their problem. And, to me, both lawyers should work together to try to figure out like what both their clients want and need and try to find a way to come to a resolution. And so I'm not scared of discovery. Like I usually have write-ups and supporting documents that I'll readily provide to my opposing counsel so that they can convince their client to, pay my client money, And so I think in that way, you want to work together. And so sometimes I just don't like the adversarial approach. And sometimes when it is so adversarial, it gets me wanting to litigate and push the case if you have strong facts. And so it doesn't really benefit anybody, right? Because maybe my client wants an earlier resolution. You don't want to get your own personal feelings involved. That being said, one thing that I do just drives me crazy when I have a great case and defendant's counsel offers my client like a great settlement, and there's nothing I can do to tell my client not to take it. I think it's a really selfless thing and not a self-interested thing that those defense counsel do. And I know, you guys do that to me. Especially in the class context, right? Because how can you tell your client, you can advise your client of all these different things, but it's a strategic move that I recognize. And it kind of, makes me like roll my eyes because, it's like you're being outmaneuvered in some sense in that regard. But, it's a hat tip to competent defense counsel who recognize good cases. A lot of my individual cases, my best cases are settled right out the gate. And then the ones that we end up pushing are my worst cases where I'm like, that's why I think it's good that companies hire like defense counsel that can recognize these things and get rid of cases that could be problematic for them.
It's probably a separate conversation, but it's interesting you say big individual settlements, because I do always wonder in those situations where defendants offer just life-changing money to a plaintiff and more than the plaintiff's ever going to get as the named representative, or just a significant amount of money, and they turn it down. And we always sort of hear, well, they just want to see the process change or they just want to make a difference. But it does seem sort of shocking to us sometimes when they turn down life-changing money. But I guess it does happen. I guess you get some clients that say, I don't want the money. I want to litigate, or I want to change something, right?
Yeah, I mean, there are people who feel like they've been wronged by the system and want to change the system because they don't want that to happen to others. We have clients who've been accused of being a sex offender and they're not, and they get denied housing and their wife looks at them funny, like, oh, are you, what do I not know? And they just don't want that to happen to anybody else, right? And so they're willing to press forward and, make a change and, work for the greater good. And I think that's commendable. But there are some people who just aren't in a position to do that. And, your client is who your client is, and you take them as they are, and you have to, do your job. So.
Yeah. So a few more questions to wrap it up. Where do you see the litigation trends going over the next year or so? I know sort of anecdotally, we've seen a few more cases regarding Social Security verification products. But, if you had sort of a, top 2 or 3 subject areas you see FCRA litigation going, where do you see it going?
I think one issue that we are seeing a lot more of is trying to expand the use of arbitration provisions or liability waivers in like tenant screening context, or, they're prohibited in an employment context, but in like tenant screening context, and the arbitration provision, in credit monitoring products are now are being used to try to prevent litigation of individual or class Fair Credit Reporting Act cases in courts. And so that is like one area that we are seeing more of. The other thing is, the standing Ramirez issues. It's the new Spokio where you're trying to figure out what claims will be successful in front of the courts in terms of standing. Seeing a lot of the collateral attack issues because of some different circuit court opinions, not here in the Fourth Circuit, but in other places. So we're hearing a lot about those types of defenses. And then I guess the one thing kind of in line with the verification is I'm seeing a lot of cases dealing with people who don't have Social Security numbers, who have credit files, and the problems associated with that. And so that's something that, my law firm is looking a lot into. And I think those are really interesting issues.
So what's the potential claim there? If someone doesn't have a Social Security number, is it an EB claim? Is it something different?
Oh, I think there's a lot of different things that you could assert depending on the fact pattern. Those types of cases are prone to having mixed files because of the matching procedures that are used. There's also, I think you have like EB claims for sure. And I think there could even be some other like state court, like equivalent type statutes, but I do think it's probably mostly EB when all is said and done. But it's interesting because of the prevalence of the types of cases we're seeing for people without socials, but who do have credit files and tax ID numbers. So.
Interesting. So Kristi, last question. How often do you get out to the Kelly Guzzo Hawaii office? And has it been the best thing you've done in your practice in the last 10 years?
Well, with 3 little kids and COVID, the answer is not going to be surprising. I haven't been out there. I've been out there once. And so I was out there more when my brother went to college out there, which was many years ago. So hopefully I'll be going there more soon, but maybe I will file a bunch of Hawaii cases. So I can get out there. It doesn't look promising anytime soon. We
both need to do a better job of getting the clients in the Florida Keys and Hawaii. So we'll work on that.
Yeah, just refer them all to me. You're contacted out. Just send me all the Hawaii people. I'll take care of it.
Well, thanks, Kristi. As always, appreciate your time and appreciate you being a guest.
Thanks for having me, Dave. I really appreciate it.
All right, take care.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.